Judgment in the appeal in the matter of D, a child.
This is a very unusual case in which the question is whether this court has any jurisdiction, that is, any power, to hear an appeal at all. The facts of the case do not matter, but its subject matter does. It is an application by a father for the recognition and enforcement of an order made by the Bucharest Court of Appeal in Romania that his son, who is now nearly 10 and has lived all his life with his mother in this country, should live with him. The application is made under the Brussels II revised regulation, which governs the recognition and enforcement in one member state of custody orders made in another member state of the European Union. The High Court refused to enforce the father's order, and the Court of Appeal agreed. This court initially gave the father permission to appeal, because the judgment of the Court of Appeal raised what we considered an arguable point of law of general public importance. The mother then raised the question of whether we had any jurisdiction to hear such an appeal. The Constitutional Reform Act, 2005, which set up the Supreme Court, provides that an appeal lies to this court from any decision of the Court of Appeal in England and Wales in civil matters. But this is subject to provision under any other enactment restricting such an appeal. The question, therefore, is whether the provisions of the Brussels II revised regulation constitute such an enactment or otherwise override the provisions of the 2005 Act. An application to register a custody order or other judgment governed by the regulation must be made to a district judge in the principal registry of the family division, but it is essentially an administrative matter. Either side may then appeal to a High Court judge of the family division. Article 34 of the regulation then says that the decision on appeal may be contested only by the proceedings referred to in the list notified by each member state to the European Commission, pursuant to Article 68 of the regulation. The entry in the list relating to the United Kingdom says that the appeals provided for in Article 34 may be brought only by a single further appeal in England and Wales to the Court of Appeal. It makes no mention of the Supreme Court. This is consistent with the position under the previous EU law instruments dealing with family matters. It is also consistent with the long-standing policy of limiting the avenues of appeal against enforcement decisions, which are supposed to be quick and simple. In contrast, the avenue of appeal in civil and commercial matters is either to the Court of Appeal or, if the conditions are right, direct from the High Court to the Supreme Court. It is not known why a different approach was adopted in family matters. But in any event, the meaning of the regulation is quite clear, and its effect is to restrict the jurisdiction which this court would otherwise have under the 2005 Act. It follows that we have no jurisdiction to entertain an appeal, and the appeal for which permission was originally given must be struck out. The court will now adjourn.